Court is now calling City of Pontiac versus Philip Colton, case number 23 TRD 802. Good morning. Mr. Colton, did you understand all of the rights and plea options I explained to everyone?
For the most part, if I'm not wrong, I am entitled to a crash report or an accident report, as you said.
Well, if you're not wrong, then you want to plead not guilty today, right?
Yes, sir.
Okay, so, and that can be obtained by you and or your attorney from the law director or the prosecutor's office.
I have asked, I went to records and it is not available.
Okay, well, we can deal with that later.
Okay.
This is your initial appearance hearing. Did you have any questions about the rights and plea options I explained to you earlier?
No, sir.
Did you receive a copy of this traffic citation that was issued on November 4th, 2020?
Yes, yes, sir.
Okay, you are charged with one count of stopping after or failing to stop after an accident or leaving the scene of a crash or accident. A violation of section 335.12A1 of the Pontiac City Ordinances. If you're convicted of this offense, it's a first-degree misdemeanor. If you're convicted of this offense, you face a maximum 6 months in jail and a maximum fine of $1,000. Do you understand that?
Yes, sir.
Also, if there is anyone who is damaged as a result of your actions and you're convicted of this offense, the court could order restitution, order you to pay restitution to that victim of up to $5,000. Do you understand that as a possible consequence? Finally, if you're convicted of this offense, you face a minimum license suspension of 6 months up to a maximum 3 years. So do you understand that as a possible consequence? And how do you wish to plead to this charge? The court will accept your not guilty plea. Are you asking the court to consider appointing an attorney to represent you?
No, sir.
Okay, will you be retaining an attorney?
No, sir. I'll be representing myself.
That's not a wise thing, Mr. Colton, to represent yourself. You're not an attorney. You don't know the legal processes. So I
do have that right, though, right?
You sure do, sir.
Okay.
This case is a perfect example of how confidence without competence can derail someone fast. Today's defendant, Philip Colton, walks into a brand new courtroom with a brand new judge and decides he's going to represent himself. No lawyer, no backup, just vibes and what sounds like a crash course in law school courtesy of the internet. And that decision alone already puts him on thin ice. What makes this situation explode isn't the charge itself. It's how quickly things spiral once procedure, ego, and a no-nonsense judge collide. This judge is calm, measured, and patient, but also absolutely not the type to tolerate theatrics, sarcasm, or disrespect. And Mr. Colton? He doesn't realize it yet, but every word he's about to say is digging the hole deeper. Stick around, because what starts as a routine initial appearance turns into a masterclass on why I'll represent myself is often the most expensive sentence a defendant can say.
So you wish to represent yourself?
Yes, sir.
Do you read and write English for the record?
Yes, sir.
I'll provide you a document. It's entitled Waiver of Counsel. Take a few minutes to read it. If you find it acceptable, you can sign and date at the bottom. The court finds the defendant has executed in open court the written waiver of counsel document. In this case, Mr. Colton has decided to represent himself, so he will be pro se. Okay, Mr. Colton, I do not have a written bond recommendation from the prosecutor or law director, as this was a citation issued by the police officer, so I have to ask you a few questions. Do you live, the ticket has you at West Main?
Yes, sir.
What's the apartment number?
37.
37 in Pontiac. How long have you lived there?
4 years.
4 years? Let's see, Mr. Colton has no prior criminal history in this court. this last traffic violation was back in 2008. Mr. Colton does not represent to be a flight risk. I will set bond in the amount of $5,000 personal recognizance. And I will set this case for a pretrial conference in the near future. We're being released on your own recognizance, Mr. Colton. You're going to go, when you leave the courtroom, you're going to go to the clerk's window. They're going to give you a date and time for your next hearing. That will be the only notice you receive from the court, so make sure you put it on your calendar. If you fail to appear for that hearing, I'll revoke your bond and then I'll issue a bench warrant for your arrest, okay? You could also, the city of county, have $5,000 if you aren't here when you're supposed to be here. Do you understand?
Yes.
Do you have any questions for me?
Yes, I do.
This is the exact moment where seasoned viewers already know what's coming. Judges hear this line all the time, and almost every time, it ends badly for the defendant. Notice how the judge doesn't insult him. She explains reality. Yes, you can represent yourself. But criminal court isn't Reddit, and it definitely isn't ChatGPT. It's deadlines, procedural rules, evidentiary standards, and consequences that don't care how confident you feel. The judge even gives him a perfect analogy. Just because you have a right to do something doesn't mean you should. That's not sarcasm. That's a warning. Months in jail, thousands in fines, and a suspended license are all on the table here. And instead of taking that lifeline, Mr. Colton doubles down. This is the first sign that ego, not strategy, is driving this decision.
Okay, I am not your attorney. I am not your legal advisor. So if you're going to ask me, like you're not the first one who's going to ask me legal questions. I cannot answer your legal question, only procedure. So you have any procedural questions for me?
Yes, I do.
Go ahead.
I would like to know why I am not getting an accident report.
Mr. Colton, you're going to represent yourself. There are what we call rules of discovery. So I would advise you to talk to the prosecutor or law director's office, which is across the hall, and then they'll provide that to you.
Is there a reason you can't?
This is where we get into the situation where a non-lawyer isn't familiar with the procedures. The court doesn't provide discovery. Discovery is exchanged between the parties.
How come the records office will not give me a copy?
Talk to the law director's office. Okay?
Yes, sir.
This document right here is one of the most dangerous pieces of paper a defendant can sign. The waiver of counsel isn't a formality. It's the court officially washing its hands of protecting you from your own mistakes. Once that signature hits the page, the judge is no longer obligated to slow things down, explain legal nuance, or correct procedural errors. From this point forward, Mr. Colton is held to the same standards as a licensed attorney. Miss a deadline? That's on you. Ask the wrong question? On you. Fail to request discovery properly? Also on you. And here's the irony. He signs this confidently, not realizing the very confusion he's already showing is exactly why lawyers exist. The system isn't about fairness and effort. It's about precision and process.
Get back in here.
Sir, get back in court.
Sit down. What's your problem?
I believe I'm getting railroaded.
This is where a lot of defendants make a critical mistake. They confuse leniency with leverage. The judge sets a personal recognizance bond, notes no criminal history, and even acknowledges he's not a flight risk. That's a gift. But gifts in court don't mean approval. They mean opportunity. Opportunity to fix mistakes, hire counsel, and take the case seriously. Instead, Mr. Colton seems to interpret this as validation that he's handling things just fine. Pay close attention to the judge's warnings about missing court. Those aren't casual reminders. That's the judge laying out the consequences clearly, calmly, and on the record. The court has now done its part. What happens next is entirely self-inflicted.
You just pled not guilty to a charge. I found you not guilty. I've accepted the not guilty plea. Be quiet! Be quiet! Or I'll hold you in contempt of court. Now, why do you feel railroaded? Because you went to the police department and asked for a copy of the report. You went to the wrong office. And any attorney would know that. You go to the law director's office, which is prosecuting this case. And you don't get it from the court. Any attorney knows that. You might want to reconsider representing yourself, Mr. Colton.
Yes.
Okay. Do you have any other noises you want to make before you leave this courtroom?
No, thank you.
Then get out of here without making a noise.
Yes, sir.
This exchange perfectly exposes why self-representation collapses so often. Discovery isn't something you ask the court for. It's something you formally request from the prosecuting authority. That's basic criminal procedure. The judge explains it clearly, repeatedly, and without attitude. And yet, Mr. Colton keeps circling back to frustration instead of listening. This is the courtroom equivalent of arguing with the GPS instead of following directions. The judge isn't blocking him. She's telling him exactly where to go. But because he doesn't understand the process, he interprets instruction as obstruction. And that misunderstanding is about to turn into something much worse.